Hello there, I'm attorney Kelly Longtin from Kelly Longtin Law, and today I want to talk to you about whether you should consider a life estate for your home. Now, a home is often one of the most valuable items of property that somebody will ever own. When it comes to ensuring that your home passes to the individuals or groups that you intend, there are a variety of ways to legally make that happen. The life estate is typically a less commonly used method. So what is a life estate? A life estate is sometimes called a right of occupancy, and it's a property law concept that allows a property owner to split their interest in real estate and other types of property into different types of ownership that can exist simultaneously. So for example, the owner of a cabin could legally split their ownership interest in the cabin, allowing them to possess and enjoy the cabin for the remainder of their life, and then at death automatically pass full ownership of the cabin to a named individual. So how do you go about creating a life estate? Using a life estate deed is one way to establish a life estate in your home. This type of deed must be drafted carefully to identify who will own the life interest, the right to possess and enjoy the property during their life, and who will receive the remainder interest, the right to receive the property when the individual owning the life interest dies. Now, once a life estate deed is properly drafted, signed, and notarized, it should be recorded in the appropriate land court's office to give it full legal effect. After recording the deed, the individual with the life interest or life estate can use and enjoy the property throughout the remainder of their lifetime. Note that the life interest holder is typically responsible for maintaining the property as well as any property tax liabilities. Now, using a trust is another way to create a life estate. For example, a property owner could title their home in the trust name and through the trust language designate who will have the right to use and enjoy the property during life and who will receive their home at the life interest holder's death. Now, two of the major benefits of using a life estate is to avoid probate and if there's a second marriage scenario. So let's talk first about probate avoidance. Whether you're using a life estate deed or a trust to create this type of split interest in the property, probate avoidance is one of the major benefits. Probate is often an expensive, time-consuming, and public process for passing accounts and property to your loved ones. Using a life estate deed or a trust as part of your estate planning can be an effective way to avoid involving your state's probate court system and passing your property on to the individuals and groups that you want to receive it. Now, beyond merely avoiding probate, life estates can create additional flexibility in how you pass your property on to your loved ones by resolving competing interests amongst beneficiaries. Now let's talk about second marriages. A life estate can be particularly helpful when someone in a second or a third or a fourth marriage wants to allow their new spouse to continue to live in the family home until the spouse dies, with the home ultimately passing to the original owner's children, who we would call the remaindermen in that situation. This arrangement can ensure that both your current spouse and your children from an earlier marriage can enjoy the property as you intend, rather than the property passing to someone whom you've never intended to receive it, such as a new spouse who comes into the picture after you've died, or your stepchildren instead of your own children. A life estate and property can also be useful in a Medicaid planning context. The homeowner may want to continue to live in their home as long as possible, but may not want their home to be sold to repay Medicaid if they should ever need to go into a nursing home and rely on Medicaid to pay the nursing home expenses. In that case, they could record a life estate deed that reserves a life estate in the home with the remainder interest passing to their loved ones. When the deed is recorded, the interest in the property would be effectively split, and if the Medicaid look-back period is satisfied, 5 years in most states currently, the value of the remainder interest would not be included in the original owner's assets for Medicaid qualification purposes. It is important to note that states can vary as to how they treat life estates for Medicaid qualification purposes. Using life estate deeds when planning for Medicaid eligibility can be an effective tool, but you should never undertake such planning without the careful guidance of an elder law attorney who is familiar with your state's rules. Even though there are some definite benefits of using life estates in your planning when the situation calls for it, there are also some potential drawbacks that you really should consider. First, when you create a life estate in a traditional life estate property deed, you're creating a type of joint interest in that property that cannot be undone without the joint owner's consent. For example, if you created a life estate for yourself in your own property with the remainder interest passing to your sibling at your death, you couldn't sell that property or borrow against the property without your sibling's consent. Likewise, if you decided that you were angry with your sibling and wanted to make someone else the property's remainder beneficiary, you could not change that remainder interest without your sibling's consent. Second, as I just mentioned, the individual owning the life interest will generally be responsible for the expenses associated with maintaining the property, and that includes all of the taxes. If the life interest owner is unable to afford such expenses, the remainder beneficiaries may not receive their full interest at the lifetime beneficiary's death because there may be tax liens or other encumbrances on the property before it can pass through that remainder interest. And third, there's a pure life estate interest does not protect the remainder interest from the remainder beneficiary's creditors. For example, if the life interest owner dies when a remainder man is going through a lawsuit, a bankruptcy, or a messy divorce, that person's remainder interest could easily be seized by an opposing party to satisfy the remainder man's debts or other legal obligations. In such a case, a trust with asset protection provisions would be a more effective tool for protecting the remainder beneficiary's interest from such threats as those. Life estates can be an effective and straightforward method for accomplishing certain estate planning goals, but they are not necessarily the right tool for all situations. Talk to your estate planning attorney to determine whether life estates make sense in your particular situation and to get help properly implementing this powerful strategy. I'm attorney Kelly Longtin from Kelly Longtin Law, and I hope that you all found this extremely beneficial in helping you to understand life estates.